Morning, everyone. It is hard to believe, at least for me, that it's January. But here we are in the new year. And although we have a new year, the issues that you all face really don't change that much. They just kind of grow. And so we're going to talk about some of those issues today. So thanks to everybody for joining us. For those of you who don't know me, I'm the compliance specialist here. I spent almost 25 years practicing management and management side employment and labor law with a large firm downtown, and I retired. And I have the pleasure of doing this, and I love it when people ask questions. So please, I'm very casual. Ask any questions in the Q&A. I think that's the box that's working today. That you might want, and we'll try to get to all of them. Also, comment if you have ideas for future seminars, please let me know, or let your CTR rep know, because we're always looking for ideas that appeal to people to do these. We do these the second Thursday of the month. And then we have a couple of seminars throughout the year as well. But please feel free to pipe in with any ideas that you have. There is, if applicable to you and you want it, there's 1 hour of SHRM credit for this. And, we do record these and provide the recordings. It usually takes us about 24 hours to get the slides and the recordings out on our website and distributed. So give us a little time. But if you have to step away, don't worry, because you can come back to this and you can hear anything you missed. Or if you have insomnia, that's my standard joke, you can also listen to this at night. So here's our basic agenda for today. We're going to talk about discrimination and harassment mistakes, employee classification, which anybody who's been around the block knows that's the Fair Labor Standards Act type of issues. And obviously, we can't cover every issue under the sun with these, but we'll hit some highlights or lowlights depending on how you look at things. And we'll talk about terminations and some pitfalls and best practices there. Handbooks. Who doesn't like to discuss a good handbook, really? And then workplace investigations. So that's our outline. So if you come back to this and you're looking for something, that's the general course that we're going to follow. So discrimination and harassment. I sound like a broken record on this. The biggest mistake that you can make, and usually the mistake is made because there is a disconnect between HR and whoever purchases all the insurance for your company. So that's often like a CFO or a finance person or something along those lines, who's buying the insurance and making the decisions as to what policies you should have. You really, 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 did I mention really, want to have employment practices liability insurance, especially if you're small. So I've run into the comment before of, hey, I only have like 8 employees. I'm not big enough for those federal laws. That's true for a lot of them. A lot of those laws start at 15 employees or more. But guess what? If you are in the state of Pennsylvania, we start at 4 employees or more. I think it is short-sighted not to have this insurance. When I practiced, and we only represented employers, we never represented employees because we always wanted to be consistent with our positions on issues. Our folks would just cringe when we had an employer call us who did not have this coverage, because especially if you're small, you just can't afford one of these lawsuits, and it becomes sort of a millstone around your neck if you have a high-risk employee that you want to terminate, but you don't have this coverage because the risk, right? This is the way to sell it to the bean counters in the company. The risk of how much you're going to pay to defend one of these lawsuits, even though most of them never go to trial, you're still paying buku bucks to attorneys. You don't want to do that. The potential risk, if you have a situation that is problematic, so far outweighs the premiums. And if you have this policy in place, then termination decisions, particularly high risk ones, right? The employee is in every protected category under the sun, and you know that one of your other employees said something rude to them that could be construed as a slur or something. But this employee who's in every protected category under the sun is just a horrible employee who doesn't know what he's doing, doesn't show up, whatever. All of a sudden, this becomes a dollar and cents issue because it's the deductible under the policy and the headache of litigation rather than a risk the farm type of situation if you don't have this coverage. So, I cannot stress this enough to have this. Taking one of these cases just to summary judgment, that's not a full trial, but just sort of trying to get it dismissed. You're probably looking at least six figures in attorney's fees. You do not want to take that risk, especially as a small employer. So please have this for your own sake. And I promise I'm not getting a cut from the insurance company. Okay. That I used to tell our clients this. In fact, if anything, attorneys actually hate these policies in a certain sense. It's good for you, but what attorneys don't like about them, and I'm giving away all the state secrets here, they cap our fees, right? So when I used to practice, if somebody had EPLI, we would look at what the insurer was willing to pay our firm to see if we would accept the case. And we were panel counsel on a lot of the large insurers' panels, but they were paying us rates that were much lower than the rates that we would charge without the insurance present. And the reason for that is attorneys are willing to accept a lower rate because it's a steady stream of these cases, right? We're getting them from the insurer is a steady stream, but the downside of that is we take a lower rate. So in any event, have this. I am not getting a cut. In fact, from an attorney's standpoint, if we looked at it strictly financially, the attorneys don't love these, but we do these because it's a steady stream of business. All right, that's probably more than you wanted to know about law firm economics, but it's out there. Also know what you have. If you do have EPLI, they are not all created equal. I have hit on this a number of times, but it's so worth repeating every single time. Know if your EPLI coverage handles any wage and hour claims. Oftentimes, those are excluded from these types of policies and require a separate rider. Know whether or not these policies will represent other individuals in the company, not just the company itself. Because remember, if you're a corporation or a partnership or LLC, whatever your little format is, and that's not my specialty at all, but it's good advice to have some sort of corporation framework in place. Know whether or not this policy is going to represent any of your employees if they're accused of engaging in some sort of misconduct. So let me give you a real life scenario. VP of a company, well respected, well thought of, is accused of sexually harassing a female employee. It's a he said, she said situation. Can't really tell who is right. You know, it's just two people saying, hey, this happened. We don't have any other evidence. We don't have text messages. We don't have video footage. We don't have anything that would be the smoking gun. And our VP, who's been with us 20 years, is saying, hey, this is a shakedown. I didn't do it. Emotions are running high and all that. And the lawsuit, when it comes around, accuses both the employer, company ABC, as well as VP XYZ. They're both named as defendants. And your company may make the decision of, hey, you know what? We although we can't prove it in this he said, she said situation, we tend to think our VP is, the right one to believe. It's a judgment call, and we want to help him because he can't afford, or she can't afford, these legal fees, right? They're ridiculous. If you've looked at legal fees recently, the firm that I was with, the partners are in the $600 to $800 an hour range. That is really, really expensive. The associates are a little less, but they're still expensive. He can't afford this, and we want to help him. Will our EPLI cover somebody like that who is named in the lawsuit? It's going to cover our company because this is a harassment lawsuit, but will it cover him or her? The other one is FMLA. I don't know if you know this, but managers who interfere with FMLA rights can be individually sued. And so you have to look at your EPLI and know whether or not it's going to cover an FMLA claim, because that's not your typical discrimination and harassment claim. And you have to know whether or not it's going to cover the managers who are involved in the decision making as to whether or not the employee is entitled to FMLA leave. Real life story, because who doesn't like a few good war stories in January, as we're all freezing, or at least I'm freezing. The nursing home, I may have told the story before, had a Don, a director of nursing, as well as an HR manager. They had an employee request FMLA leave. They said no to the leave. Now, when they talked to us, which they should have talked to us first, because an ounce of prevention is worth a pound of cure, that decision was probably wrong, but it wasn't made in what I would call bad faith. There was a misunderstanding. The employee turned around and sued. She had a great lawsuit. She alleged she had to leave because of the wrong FMLA decision, and she had a pretty serious health condition. She had multiple sclerosis. She sued the company as well as those two managers, the Don and the HR. And so the company wanted to help those two individuals, but guess what the EPLI did not cover? That was a really heartbreaking situation because those two ladies who served in those roles did not have the financial resources to defend that or to pay out any settlement. So difficult situation. So even if you have the EPLI, know what you have, know who it covers, know what kind of claims it covers, because again, wage and hour, leaves of absence, sometimes those are excluded, and you need to know whether you need an additional rider for that to the insurance policy or not. Or at least if you say, hey, I'm just going to go with the standard EPLI, the basic bare bones policy, then at least you know where your risk lies and what is covered and what is not covered. And again, I promise I'm not getting kickbacks from insurers. Okay, moving along. And again, if you have any questions, please let me know. So moving along, have a discrimination and harassment policy. I know that sounds like, oh, somebody has raised a hand. Crud. And I am going to try, because I am really bad at this. I am not seeing a question. Let me see here. Okay, if somebody had their hand up, let me know, because I don't know if it's because I'm incompetent with technology, and I admit to being incompetent with technology. If I lost you, I'm very sorry. Please just type a question in the Q&A or the chat. One of them's enabled, one of them's not. Oh, so somebody asked, and so they want me to finish the story, which I'm always happy to finish the war story. What happened in that situation? So this is a lesson to all HR folks too. The owner of the nursing homes, assisted living centers, was not the most stand-up person in the world. And I know that's going to come as a shock to you that an owner of a company and would not be a stand-up person. And really, while I'm making a joke there, the vast majority of employers that I worked with, I always felt really good about representing. This one sometimes raised some eyebrows. His position was, well, tough luck. They made the decision. It was the wrong decision. And our interests aren't aligned because I want to blame them anyway for being incompetent in their FMLA decision. And it took some, what I'll call browbeating by our firm to be like, hey, in actuality, there are some things that are aligned here. interests, and you don't really want to alienate your two star witnesses, even if they made some mistakes. And because they didn't have good coverage for this, we got them to settle. And the unfortunate way that this sort of played out, but it wasn't really completely the employer's fault. The employee who left, her house went into foreclosure. And because she was desperate for money, she was willing to take a settlement that frankly was far below what we had valued the case at. And so the employer, the owner, and they had hundreds of employees. This was not a small mom and pop operation, ended up paying the settlement because it was a good deal for the employer, and at the same time got a release, because when you pay a settlement, you don't just hand out money and not get something in exchange for it. The release at our urging covered the Don and the HR manager. So an important lesson, perhaps, or an important highlight. And again, I always did management side, never employee side cases. Vast majority of employers will stand up and help their employees, particularly if they think the employee has acted in a forthright manner. But you do have this exposure as an HR person if perhaps that's not the case. So I hope that answers the question as to what happened. We got it to settle. It needed to settle, and we got the two employees out of it, but it was a sticky mess. And the employer was not willing, at least initially, to take responsibility for providing coverage or representation of the two individuals. Okay, I'm not at all sure what happened. I hope everybody can still see my screen, because one of my screens just went blank. But hey, we're going to press forward. If there's any issues with seeing it, let me know. The other time, just to close this loop, the other time employers do not want to help employees. So take the original VP situation. In that case, we thought he was a stand-up guy. We highly questioned the employee who accused him of sexual harassment, meaning there were some things about her that were red flags. But I've had the situation go where the VP was guilty of sin, to use an expression, and was guilty of the harassment. And that person got sued individually along with the employer. And the employer, because the employee was guilty of sin, and because their interests were not aligned at that point, right? We had an employee who had gone to another employee's hotel room and done things, and just, it was icky. That's a high-tech legal term, icky. The employer did not want to cover that person, because if the EPLI doesn't cover that person, the HR person, the VP, whoever it is on their own, or the employer's paying full freight for them to be covered. Okay, so somebody has asked it, and this is a great question. Was the HR employee blamable or liable because of their title, certification, or because they made the decision autonomously? I mean, sometimes I'm just doing the dirty work, but under direction. Hey, that is so true. Sometimes for HR people, and I think everybody, if I said raise your hand if you've ever been in this situation, but I won't, has had to do a termination or something because the supervisor is adamant, and you're saying, hey, that's kind of a high risk termination, or I'm not sure you have your ducks in order, supervisor or VP or whoever, but you do it anyway. So in FMLA land, and this is not true of discrimination and harassment necessarily, there is a private cause of action against anyone who interferes with or retaliates against the person who was seeking the FMLA. So it, like the Dawn, the director of nursing, it's not because she had any specific title or HR expertise or anything like that. And the HR manager who was involved in this decision, it wasn't because she had a certain SHRM certification or her master's in HR or whatever it might have been. The only criteria is, did the person interfere with or retaliate? And typically these lawsuits only happen to people who have some type of supervisory authority. I've also seen it happen to first level managers who are ticked off, since this is a family show, that the employee is taking time off and they say something to the employee or do something. What they don't realize is, even though they're not in an HR function, they're just the supervisor, that they have perhaps interfered or retaliated against the individual for trying to take the FMLA leave. So to answer the question in a long-winded way, and we'll try to move on just so we can catch everything here, but I will stay as long as we want to talk about questions here. It's not because you hold a certain position or a certain title or a certain degree. It's your actions that trigger the liability for FMLA. And for harassment, it's usually some type of assault or battery claim, meaning, you touched the person, they thought you were going to touch them, you did something like that. That's usually what triggers the individual liability. So I hope that answers the question. Okay, so moving back here, which that was a really good discussion. So thank you for those questions. That's a better learning experience for everybody. What's in the policy, right? Please read your policies every year. I know handbooks are boring and nobody wants to read them. And we'll cover handbooks a little bit later, but things you're looking for that are huge hot buttons for the Equal Employment Opportunity Commission is, who does the employee talk to if they have an issue, whether it's discrimination and harassment or anything along those lines? Who are they supposed to go see? In an ideal world, and particularly if you're large enough, you have two options, and you list them by titles, not by names, because I guarantee you people turn over in these roles and nobody looks at the policy, and all of a sudden it says, go see Jim Bob, and Jim Bob left 5 years ago to go back to his hometown or something. So you want two options, and the reason for that is, what if one of those people is the one engaged in the harassment or the discrimination or whatever bad actions it is? The employee needs two people to talk to, titles, not names, preferably folks who have some knowledge of the law. A first level supervisor is usually not the world's best idea, because they're often friends with the employees, or they don't recognize the seriousness of what has been said to them. Make sure all protected categories and all laws are covered. That's particularly true if you are in multiple localities in multiple states. Sometimes things are covered out west in California that aren't covered here, or there's other laws that they have that we want to make sure are in place. Look for new laws, right? Do you have the Pregnant Workers Fairness Act included in your handbook or even in this policy? Because if somebody takes PWFA leave, you can't discriminate against them for that. You can't harass them for that. You can't retaliate, which, by the way, retaliation is usually worse than the underlying claim. So what you see is a situation where the underlying claim, and again, this needs to be in your policy, that you prohibit retaliation and who they can talk to if they have a problem. You may have an employee who genuinely believes they've been discriminated against. But when you look at it, you say, no, they're just being disciplined and we're doing it correctly. We're doing progressive discipline. We're treating them the same as everybody else. That's just their perception that it's because they are a certain race or ethnicity or whatever it might be. But they have said it was their supervisor who did it. And these claims are highly emotional, and the supervisor is ticked off to no end that this person has said they discriminated against them, because the supervisor's like, hey, I'm an upstanding guy or gal. I would never do that. I can't believe somebody has said that. And so they start treating the employee differently, usually in a bad way. And so while the underlying case was highly defensible, the retaliation claim is not. And now you're in a really poor position because the retaliation occurred. The underlying claim was no problem, whatever that was, but the retaliation is a problem. Ideally, you want to show a review of these policies yearly and note the reviews. You should have a little header or footer that says, hey, this was adopted originally on such and such date, and it was most recently reviewed on whatever. It's a good note to you as HR folks to do that. January is a great time to have this on your to-do list, although I'm sure you all have long to-do lists as it is. But it's just a reminder, hey, at the beginning of the year, I'm going to look at my handbook. I'm going to look at this policy, and I'm going to make sure I've got anything new from the last year. If I haven't already put it in, I'm going to put it in. Yearly trainings, and I always get the question, well, where does it say that in the law? It doesn't. The EEOC takes the position that you want training, anti-harassment, anti-discrimination training at the beginning of a person's career with you. So that's part of the new hire training. And then approximately yearly thereafter. And yes, that means the cranky folks. I'm sure none of you have cranky folks, particularly managers, who object to training once a year, but they need to do it because this is the company's liability on the line. This doesn't have to be some sort of elaborate training. This can be a video. It could be live. It can be you doing it. Just something where they sign off that they have done this and that you can prove what the format and the content of the training was. Okay, so somebody said, where can I find anti-harassment training so I don't have to create one myself? Just Google. You do not have to do anything fancy. These things come in packages just like handbooks do, relatively inexpensively. And usually for most companies, especially smaller ones, a video, a 30 to 60-minute video is going to cover everything you could possibly want or need. And so you don't need, here I am again, spilling state secrets. You don't need an attorney to come in, although you could, or an HR advisor, you could, but you don't necessarily need that. The only time that I think you need a live person to do the training who is well informed is when you think you have a problem. And so oftentimes I would do trainings for really, really large companies. And I loved getting out and doing the trainings. But oftentimes it was when they thought they had a problem in a specific department. And they wanted somebody there who could field questions and who could sort of gauge where the problem might be, because sometimes you see somebody furiously taking notes on something you're talking about, and that can be sort of a red flag that, hey, that person's really concerned when I start talking about pregnancy discrimination or whatever it is. And so most of the time, a little video course that they watch is good. They sign off on it. It's all good. Okay. So somebody else piped in with information that might be helpful to others. They said, we use Alchemy for our harassment training. It is a web-based program. We also use JJ Keller for our drivers. So there are lots of options you can use that people have used successfully. There's no magic to this. Do what is financially responsible and appropriate for your company, but make sure the cranky folks and the bosses attend. Somebody else said, training should include information on harassment and company policies, correct? So ideally, yes, but let's say you're using a video service. Something is better than nothing. And oftentimes the way you do this is, let's say you're distributing this electronically to everybody. You got the video out there, you distribute your own policy at the same time. And then the acknowledgement, and this is a good point, the acknowledgement says, hey, I watched video XYZ. It was great. It was exciting. And I received and reviewed a copy of company ABC's anti-discrimination or anti-harassment policy. So that's an extra layer of protection to say, not only did we do the training with a video or whatever we used, but we gave everybody yearly a copy of our policy, which hopefully we've updated before we've handed it out, that says who they should go to, what they should do or shouldn't do, and sort of has the law of the land and our company's position on it as well. Okay. Last but not least in this category, and again, I love the discussion, so thank you, everyone. Climate, bystander, or similar type of content or surveys. The EEOC has been pushing this for the last year or two, saying, hey, we think you ought to do climate surveys. That has nothing to do with how cold it is outside. It has to do with how do you feel about our workplace, right? And the climate survey doesn't necessarily have to say, hey, have you been discriminated against here at company ABC? But you're looking to try to figure it out if you have an issue somewhere. So this is not required, but the EEOC loves it. Whether they'll continue to love it under the new administration, I don't know, because obviously we have a change of the guard here, and I'm not getting political. There's just different positions. And bystander training means you train people during your annual training of what if I see discrimination, harassment? I'm just, Joe Schmo on the production line, and I'm not getting harassed, but I see, oh, poor Ann Lavelle, that one supervisor, he demands a kiss every time she gets out of the elevator, which, by the way, was a case I had. First level supervisor decided to demand kisses of the women coming out of freight elevators on the plant floor. That was not a good thing to do. So bystander training would say, hey, Joe Schmo has been trained how to raise his hand and report the harassment that's happening to one of his coworkers. Okay, moving along here. Let's go to the FLSA. So a little change of pace here. It's not all about salary. That's the biggest point that everybody, I shouldn't say everybody. If we're going to miss the obvious, this is what we're going to miss. A lot of times owners, in particular of small companies, think, hey, I paid a salary, they're exempt. They couldn't be more wrong. And sometimes you've had what I'll call a mom and pop company that has grown. And so originally, mom and pop had everybody as salary because they thought anybody who had a salary is exempt. They don't need overtime. And that thought process and that standard has just grown with the company. You need to make sure that the employees meet the duties tests as well. And we have done a number of seminars on the duties tests, and they're not easy. The main exemptions are executive, administrative, and professional. The administrative exemption will always be your most likely stumbling block because it's hard to know whether somebody's exempt or not. And I see I'm getting more questions. I promise I will circle back. Just give me a minute or two here. Difficult. And even the courts are in disagreement as to who's administratively exempt or not. The other major mistake that's out there, besides thinking that anyone whose salary is exempt, beware of local law. So I've pointed this out before many times, but local law doesn't always match up with the FLSA, and that's true in Pennsylvania. We don't recognize some of the exemptions that are recognized under federal law, the most obvious of which is the computer professional exemption, which allows you to actually pay an hourly wage to somebody who meets the duties of the computer professional exemption. Pennsylvania does not recognize that. We recognize that could be a possibility to have that person exempt as a professional if they're paid a salary. But if you pay them hourly, even though the FLSA says that that might be okay, state law will say it's not. And there's lots of examples that we could go through, but we're running out of time, where state law diverges with different states and different localities from the FLSA. Document why you believe a position is exempt. That way, if you get a Department of Labor audit, you have something to give them. And that's usually a job description that says, hey, here's what they're doing. And hopefully it accurately reflects what they're actually doing. And we looked at whether or not they're exempt. And this is why we believe they're exempt or not. And watch that jobs do evolve over time. So 10 years ago, the company's accountant may have run everything for the finances. But here we are 10 years later, the company's grown, and the position of accountant is really bookkeeper now, and that's not exempt. So do be careful of things that morph over time, and have language in your handbook requiring employees to notify you of any wage payment mistakes. So if we accidentally violate the salary payment one time innocently, and they tell us about it, we'll fix it. We'll fix it promptly, and that doesn't ruin the exemption. Let me turn to the questions real quick. So if an employee claims disability of any sort, does the employer have to refer them to FMLA? This is noting that the HR policies go over FMLA, and we have all the FMLA posters displayed. Well, that's good. You should have an FMLA policy. You're required to have one. And of course, the posters. There's tons of posters out there at both the federal and state level. The question is, do I have to, they have some sort of disability, do I have to tell them about the FMLA? I don't know why you wouldn't tell them. So I'm not sure that silence is the equivalent of interference in an FMLA claim, but for the employer's own benefit, I want them to burn through their FMLA time concurrently with their disability leave, because I don't want them to come back after being out on disability for, let's say, 2 months and say, hey, now I'm pregnant or whatever it is. That was just the first thing that came to my mind. And I'll be taking my 12-week FMLA leave in December when I have the baby. I don't want them to be able to double dip like that. I want to have run the leaves, the disability and the FMLA leave concurrently, so that they don't have a pot of time sitting when they come back to work, assuming they're coming back to work, that they can now use. Okay. All right. So let's talk about a couple of conundrums with the FLSA. What if we have an employee who is exempt, right? They work Monday through Friday in some sort of exempt position, but they need a little extra cash. You know, Christmas was expensive. We can all identify with that. And they want to fill in as a non-exempt cafeteria worker on the weekends. You desperately need those cafeteria servers on the weekends, and you agree. Is the employee still exempt? You probably have a huge problem here from a couple of perspectives. If we flip this, if we thought about it from the Department of Labor and the employee's viewpoint, we could see where an employer could potentially abuse employees by separating out jobs and saying, hey, normally this is non-exempt, but because you do another exempt job, now everything's exempt. It doesn't work that way. And usually to prevent this type of abuse, where we're sort of saying, hey, this job, that job, whatever, and not looking at the whole of their employment with you guys, the DOL takes a very dim view of that. And so we may have ruined the exemption because we may now have an employee who's working too much, too long at the non-exempt job. You know, exempt employees can do some non-exempt work. It just depends how much and how that interacts with their other duties. Because when we look at the duties test, it talks about that their main duty, the main proportion of their work is spent in exempt duties, not in non-exempt duties. And the more non-exempt work they do, the more problems we have. And we probably also have the issue, if we turn them accidentally into non-exempt, that we haven't paid them overtime. If they're working all week long plus the weekend, clearly they're more than 40 hours, we probably have an issue. That gets us into the area of weighted average overtime, which was a different seminar or webinar that we did as part of an FLSA discussion. And we probably haven't paid them the appropriate overtime. Here's another conundrum. What if we have two employees, both do the same duties, which the employer believes to be exempt? One is paid hourly and one is paid salary. We take the position that the salaried employee is exempt. Do we have a problem here? So this is a bit unusual, but it does happen, particularly when we have a situation where somebody wants to work less hours than what we consider to be full-time. Nursing is a great example of that. Salaried nurses are professionals. Usually they're hourly, but if you have a salaried nurse who's actually doing the jobs of a nurse, they're probably exempt. So you could have somebody who's working full-time as a nurse who is exempt because they're being paid a salary that meets the FLSA threshold or the state or local threshold. And somebody who says, hey, I just want to work part-time, I'm doing the same duties, you can pay me hourly. We don't necessarily ruin the exemption, but we do have to have a reason why we have a difference in the pay like that. Both because we want to make sure we're complying with the Equal Pay Act, as well as we don't want the DOL to be like, this doesn't make sense at all. But if we have a rationale as to why one's hourly and one is salaried, we can do this. All right, terminations. So an ounce of prevention is always good. What is that ounce of prevention? Especially if you're dealing with a large layoff, it usually means talking to counsel. And the benefit of that with a large layoff is what an employee side attorney is looking for is a pattern that says, hey, we picked all the old people, we picked all the women, we picked all the minorities, or whatever it is. And obviously nobody's doing that, but sometimes we can inadvertently create a pattern that skews our numbers. And if you discuss this with counsel, it's protected by the attorney-client privilege. And you can kind of look at that and say, hey, do we have any pattern here that's going to be concerning? We didn't mean to create any pattern, but maybe because we wanted the people with the largest salaries on the layoff, we picked everybody who's over 40 because that's who has the largest salaries. So if you have a concerning case, and when I say talk to counsel, I mean talk to a labor and employment attorney, not a general practitioner. General practitioners are wonderful for some things, but it's just like the medical field. You would go to a specialist if you had this issue. Make sure in just a single termination that you have documentation and follow progressive discipline. That is one of the biggest arguments that you see in discrimination and harassment cases from the employee is, hey, the handbook said I'd get, a verbal, written, suspension, whatever, as part of the progressive discipline, and I did not. What if you do document your terminations and your discipline, and the employee wants to write a novel about why you're wrong on the termination form or refuses to sign it? I don't care if they refuse to sign it. If they want to write a novel about why you're wrong, let them do it. Because it's going to show one of two things. It's either going to show we have issues that we didn't know about. So going back to somebody's question about, hey, sometimes I'm just doing the dirty work. Somebody tells me just to terminate the employee and, I'm not completely sure, but I terminate them. Those people who, those other supervisors who said, hey, terminate this guy, he's terrible, he's incompetent, may have omitted to tell you something. I know that never happens, but just hypothetically. And if the employee writes his novel or her novel about why this is wrong, you may find out some very important facts that the other folks in your company failed to tell you about. And maybe that needs to be addressed. Or the other alternative, which is usually more likely, is the employee locks themselves into a position and says, hey, I know I was late like 100 days, and I know I'm a lousy employee, but my car didn't work and I couldn't come in and I was really tired from the party, and you wouldn't believe what they write. Let them write it, because then if you fire them and they turn around and sue you for something, you can say, hey, in their own words, they told us they were late, not because they had a disability, but because their car wouldn't start and their kid had something at school and they were out late, not, for the Steelers game or whatever it was. Let them right away. It's amazing what they'll put down. Okay, make sure that you're following prior precedent. This is the other one that gets flipped in employers' faces all the time. So you haven't followed progressive discipline, or maybe you have, but you didn't do it the same for Ann as you did it for Joe. And so one of the questions when people would call when I practice and say, hey, we're about to terminate Ann. She's just the worst employee we've ever had. And do you know what she did? She did X, Y, and Z. And I would say, well, have you ever had anybody else do X, Y, and Z at your company? And what did you do if they did X, Y, and Z? And sometimes there's turnover. The HR person doesn't know whether or not in the past 20 years, because they haven't worked there for 20 years, what they did for X, Y, and Z, or whether they've ever even had X, Y, Z occur before. And then Ann, who has worked there for 20 years, knows that Joe did X, Y, and Z. And the supervisor laughed it off, even though it cost the company $5,000 when he made that mistake with the extruder. But when Ann made the mistake and it cost the company $5,000 with the drill press, we fired Ann for company violating company policy on, destroying company property or something. That's a very difficult problem if you're sued for discrimination and harassment and the employee can show that other employees were treated differently. If you have a past practice that you want to change and you say, hey, the prior HR person, I don't know what that person was thinking, but they let everybody do whatever, come in late, whatever it might be. You want to change that, you need to announce that, publish that, say, hey, we're no longer taking or doing XYZ. You will be disciplined. Here's our section in the handbook that talks about it. This is, forewarned is fair warned type of thing. And if you do this from this date forward, it's a problem. And that way you sort of show that there's a change in past practice that has been announced to folks. And therefore, if we're changing it, they know about it and they deserve the discipline if they go against that. All right, this is the biggest single conundrum that I think employers face in terminations or discipline settings is what if the employee says something that makes you cringe during the termination or discipline? Do you reverse course? And when I say cringe, I mean the employee says, yeah, I was coming in late every day. I told my supervisor that I have mental health issues and we're adjusting the medications. I told them I would be late and I'd have a problem for 2 to 3 weeks. What do you do? Arguably, that person put your first level supervisor on notice of an Americans with Disabilities Act issue that should have been looked into, and you didn't. And now you're disciplining or terminating the person for attendance issues. Do you reverse course? So the first thing I would do is we never take the employee at their word. We want to hear what our supervisor says. So often the way we do this is we say, look, we're going to look into this. If this was a termination, in the meantime, we're sending you home without pay, assuming they're hourly. It's a little bit more difficult if they're salaried exempt. But we're going to look into this. We may still terminate you. We may not. And we do look into it. And if they're right, and the supervisor goes, well, yeah, but I don't care about mental health issues. You say, Ann's just crazy to begin with. I don't care if she's showing up late because of mental health or because it didn't matter. I don't want her working with me anymore. We may reverse course on the discipline or the termination. But we're not going to take the employee's word for it at face value. We're going to investigate. We're going to look into it. We're going to find out whether or not what they said that made us cringe is true or we think it's true, and whether we have a problem here. If we reverse course in my little scenario there and we bring Ann back, we've got to really watch that supervisor, that the supervisor doesn't retaliate against Ann, because that supervisor probably is going to be ticked off about the whole situation. And we probably need to retrain that supervisor if that supervisor didn't recognize, right? It's not their job to address the situation. It's their job to recognize that there may be an HR issue and send it up the flagpole for us as HR professionals to address. They can't just sit on information. So something to think about. Severances. So these can be great. I don't necessarily think you throw them at everybody. But with a large layoff, I do see value to them because oftentimes that's driven by business decisions and not performance by the individual. Again, we talked about talking to counsel to make sure you don't have any group that you have somehow inadvertently singled out. The other thing I want to point out that most employers don't know is that if you have a routine practice of handing out severance, or you're going to do it for a large layoff, you have to look at whether or not your severance program is actually an ERISA employee benefit plan. And there's different schools of thought on that. but be aware that that exists. And for those of you who belong to our mineral HR service here, by sheer dumb luck or coincidence, the question of the week today is employee benefit plans and needing a plan document and an SPD, a summary plan description for health plans and retirement or 401k type plans. Absolutely, you need that. If you have a severance plan that qualifies as an employee benefit plan, guess what you need? A plan document and an SPD for it. That can be a lot of work. If you're a small company, you don't want to be doing that. Probably if you're larger, you might want to do that to lay out the terms of your severance plan for folks. So just be aware that that little thing is out there. Severance can be great as a carrot to keep people to stay. If you're closing a plant or something or a location, say, hey, if you stay on this long, you're going to get this severance. And that way, you don't have everybody running out the door looking for a new job. You say you've given them a carrot to stay on and help you transition. Does it open the floodgates? I don't buy into this argument at all, because I think everybody knows, every employee out there knows their uncle's cousin is an attorney, has heard of severance before. It's not like we're giving away some state secret if we offer severance to somebody. But I do think we use it judiciously. If we have a firm ground that we've terminated the employee on, I'm not sure we go throwing severance at them. If we have a higher risk situation, maybe we look at it. By all means, remember that the termination and the severance is not your only chance to resolve this. Almost all litigation resolves. It's really like a delayed severance, but you've made the employee work for it. And that can be a good thing, to say, hey, we don't just throw money at terminated employees, especially if they've done something wrong. We're going to make them work for it. This may resolve itself. And remember, you have EPLI. There's no point in throwing severance that's really expensive at an employee if your deductible is actually less than the severance on the EPLI. So remember, you've got EPLI, and whatever you offer as severance, if the employee rejects it and says, I'm suing you anyway, know that that is now probably your ground floor for negotiation. So if you've offered a $5,000 severance and now you've been sued, that employee is going to presume that the number will only go up, and their counsel will presume that too, will only go up from whatever you offered as severance. So do think about that as well. Handbooks. All right. We're running out of time here. I will get to everybody's questions. Have one. And no, I'm not joking. Have one. Most people do. You can get one very cheaply. If you do that and you get one off the internet, please make sure that it makes sense for your company. Oftentimes, startup businesses start without one. Not the world's best idea, but I can understand it. And as they grow, which is great, they never put one in place, or they put one in place that they got off the internet for $25 and they never put their company name in, or they didn't do the yearly review, right? Do you have the PWFA, the Pregnant Workers Fairness Act? If you're local, or even if you're not local, but you have employees in Allegheny County or the city of Pittsburgh, do you have the leave laws put into your handbook at this point? Do you have those fun posters too? Watch if you are in other states. That always leads to the conundrum. Do you have uniform language in the handbook that says, hey, we do this? This is a great example. It's a use it or lose it vacation policy. That's fine in Pennsylvania. It's illegal in California. What if your handbook says we have a use it or lose it vacation policy, and one of your employees works remotely out of California? It's not where you are, it's where the employee is. What do you do with your handbook? Do you create an addendum for California? You could, but for one person, that's probably a lot of work. Do you just leave the language and hope the person doesn't notice that they're entitled to vacation time if they leave out there? It's not use it or lose it. Or do you put some sort of what I'll call weasel language in that says, hey, it's use it or lose it unless otherwise required by state or local law? And it really depends how many people you have in that location. If you have 100 people in California, I wouldn't use weasel language. I would have an addendum. If you have one, you might use the weasel language, and just be aware of what the law is, so that when they quit and say, hey, I want my 2 weeks of vacation, I never used it, you have to pay it out if you're in California. All right, workplace investigations. And again, I will get to the questions. We're just running very close on time here. So, but I love the discussion. Outside investigator versus inside. In other words, somebody has come to you and said, Ann's come and said, hey, Joe keeps pinching my butt. I don't like it. I think Joe, who's my supervisor, is discriminating against me because of my ethnicity, whatever it is. Do you do it yourself? Do you get an outside investigator or an HR consultant or somebody like that? We used to do investigations in high risk, high value situations. Just know that whoever does the investigation, internal or external, you turn them into a witness. So be aware, you need whoever's doing this investigation to be the type of person who would be a good witness in court. If you're doing this internally yourself, ideally it's nice to have a witness with you. So sometimes it's an HR manager and like the CFO or somebody like that who is not being accused of the whatever's gone wrong, so that you can say, hey, it's not just me who's bending the truth. It's or doing the questioning and is accused later of misrepresenting the investigation. I have two people who say the same thing, who are in the interview with the employee and the witnesses and the alleged perpetrator, and we both have the same recollection and the same notes and all that good stuff. Document, you have to store this away from the personnel file. You can't store it just in with the employment application or something like that. It's the same as medical information. You can't store that in an employee file either, or in a personnel file either. Confidentiality, especially if you are interviewing coworkers who may have been witnesses to this. You gotta hit it home to them that this is a confidential investigation, and anybody who blows that confidentiality will be disciplined. Who do you interview first? Typically, it's the victim, right? Usually, when I did these investigations, I talked to the alleged victim first, followed by any co-workers or witnesses or any documents I would look at that that person had. And last but not least, I would get to the perpetrator, because by then I knew what the allegations were. I knew how strong any witnesses were. I had looked for any bias or any concerns. What if somebody refuses to cooperate? Well, this is usually the alleged perpetrator who doesn't want to cooperate. If that occurs, you can't force somebody to talk to you, but you can tell them you're going to make a decision based on the information you have, which doesn't include their side of the story. If you really want to be tough, you can tell them their job is on the line if they don't cooperate, that you expect cooperation as part of your policy on harassment and discrimination. You want to warn people, especially the perpetrator, about retaliation. You're not going to tolerate it, because often the retaliation is worse than the underlying claim. And you also want to do this in a timely manner and assure everybody, the alleged victim and the perpetrator, that you're going to circle back and tell them the outcome of the investigation. What if it's he said, she said? That's really difficult. You can inform them it's he said, she said. We're going to keep a closer eye on things. Come back to us if there's more problems, and you do keep a closer eye on things. You can also make a judgment call. There's risk in that, but you can make a judgment call as to who you believe. Again, more risk if you do that. What if somebody's quote unquote guilty? Well, this isn't a criminal trial usually, but do you have to terminate? No. Sometimes people do dumb things and they don't think about it. And so we might have, there's a difference between the supervisor who wanted kisses from the females coming out of the freight elevator. That's pretty egregious, versus somebody who just keeps calling the female employees honey because they're from the South or whatever it is. You may have some sensitivity training to do with that employee to inform them that, hey, these folks don't want to be called honey and sweetheart. And, here, watch this video, go to this course. We are writing this up perhaps, but we're not necessarily terminating. Okay, your questions. I appreciate everybody hanging in there as we kind of flew through that. Okay, so somebody wanted clarification on this. Do we need a separate plan document and summary plan description for any benefits offered to someone given a severance. Not necessarily. When you have severances that qualify as an ERISA employee benefit plan, and typically what will trigger that is if you have a pattern of practice that, hey, everybody who leaves, we offer 1 week of wages per year of employment or something like that. Or we're doing a large layoff and we have a similar plan. Then you may have created, probably inadvertently, an employee benefit plan. If you're just doing a one-off now and then, you probably have not created an employee benefit plan. But it's something to be aware that that's a possibility, that if you have some policy or program that this is what we do when we terminate people because we just don't want lawsuits and we don't want our reputation tarnished, or this is what we do when we have a layoff of 2 or more people, you may have created such a plan, and then you would need a plan document and a summary plan description. And just to clarify, just because it was a question on mineral, and again, this was not planned, I just happened to see it this morning that CTR's HR function mineral had it. All health plans, all retirement plans, 403Bs, 401Ks, whatever it is you've got going there, need a plan document and a summary plan description. That is not the insurance policy or the documents that you get from your broker when you sign up for your whatever major medical plan you're offering to your employees. That document, the policy, may be part and probably should be part of the plan document or the SPD, the summary plan description, but it does not qualify as that. Because there's been more enforcement by the Department of Labor about ERISA plans and plan document SPDs in the last probably 10 years, employers have become more savvy, knowing that they need something like this for their health and welfare plans. And sometimes because employers have reached out to their brokers or whoever and said, hey, I now know that the Highmark, the UPMC plan is not my plan document. Can you give me one? Sometimes they have templates that they'll hand out and give to you, but you really need to look at that carefully, because that plan document may have language in it about who qualifies for these benefits that's different than what you use as qualifiers for these plans. And so you really have to look at that and watch that. Okay, that is everything. So I appreciate everybody attending. I think I got everybody's questions. If I haven't, please let me know. Feel free to send me a question or whatever. And I appreciate everybody hanging in there today. And I'm trying to fast forward my slides, but of course it doesn't want to. Anywho, please join us next Thursday or second Thursday of every month, and any seminars that we have. Oh, I see I have some more questions. Okay, so for anybody who wants to hang on, let me see what we've got here. Oh, everybody who's saying thank you, you are quite welcome. I enjoy doing these, and I hope it's a good learning experience for everybody. Take care, everyone. Stay warm. Oh, wait, maybe I have one more question. Hold on, let me see. It's wonderful when I could get my mouse to work. Oh, you're quite welcome, everybody. Take care.